Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly telephone call, once every 2 weeks. We answer community's questions. It does not form an attorney-client relationship, nor is this a substitute for an in-depth consultation. You would have heard all that when you logged into the call. There is a recording that informs you. With that said, I'm going to begin as usual, first with the questions I consider to be frequently asked questions. The first frequently asked question is H-1B unpaid leave or time off. So Abhijit wants to switch jobs, but he needs study time for about 3 to 5 weeks full time. Question is, can I go for an unpaid leave from my current job for 5 weeks and use this time for preparation? I don't want to tell my current employer the actual reason. How will my H-1B status get affected due to this? Can I be in the US during this time? What are the conditions if yes? If there's no option and I need to go out of the country, what happens with the visa? So let's begin with the easy one first. If it can be avoided, you should not leave the United States, because it's been our experience that the consulates will try to deny cases or delay cases as much as possible, which seems to be a part of the Trump strategy to create blocks against all immigration, including legal and high skilled. So we have to avoid that if possible. It is legal for an employee to take unpaid time off. It is legal. In fact, the Department of Labor regulations specifically, I think they give 2 or 3 examples. One I remember off the top of my head, for example, tourism. So if you said, look, Mr. Employer, I have been here in the United States 6 months or 8 months, and I haven't seen the Grand Canyon. I want to take a couple of weeks off. That should be okay. So therefore, it is normal for an employee to take personal time off, but the employer, for their own protection, should be documenting this. I do not believe that you have to give a specific reason. If you ask your employer for unpaid time off for personal reasons, that should be good enough. I don't see why not. Okay. So I'm just trying to make sure that you guys can hear me. Give me a moment. I think I was on mute maybe. Hold on 1 second.
You are now a host.
1 second.
The conference is now in conversation mode.
A bunch of people logged in and logged out. I'm not sure you guys can hear me. Can you hear me? Hello? California, I just unmuted you. Can you hear me? Can you guys hear me? Hello?
All participants are now unmuted.
Hey guys, can you hear me? I'm not sure you can. Hello?
Line unmuted.
Can you guys hear me, folks? Hello? Can you guys hear me?
Yes, sir, we can hear you.
Oh, okay. I think something went wrong. I've been talking for about 4 or 5 minutes, but I think I did something wrong. Let me double check it. I'll get back with you in 1 second.
The conference is now in presentation mode.
1, 2, 3.
The conference is now in conversation mode.
Could you folks hear me when I said 1, 2, 3?
Yes, we were able to hear you.
Excellent, excellent, excellent. So we are back on track. Okay.
The conference is now in presentation mode.
So I'll repeat myself. I had Actually, I've been recording this, so you'll be able to hear the recording anyway. I was just beginning to answer the first question, which I consider to be a frequently asked question. This gentleman, Abhijit, wants to change jobs, and he wants to take 5 weeks off, 3 to 5 weeks off in between. So the first question is, can I do it? And the answer is sure. The law allows employees to take personal time off as long as it is not an excuse to be without a project. So if you're in the middle of a project and you want to take 3 weeks for tourism, US Department of Labor specifically allows that. So the first question is, can employees take time off for personal reasons? The answer is yes, as long as that is not an excuse for being out of work. Now the second thing Abhijit has a problem with is that I don't want to tell my current employer why I'm taking time off. And the answer to that question is, you don't really have to. If you give them a reason saying that I want personal time off and you document it for them so that they are not on the line to pay you, I think that should be okay. But there is a practical difficulty. If you file an H-1B and you don't have most recent 3 pay stubs, you will have to explain your situation. And with this government, I try not to get into an argument at all. Even where I know that I'm legally successful and I have a good position, I would rather not argue. So I think this is the way you should do it, Abhijitji. Go ahead and file your H1 first and then take time off. So when your papers are filed, you have the most recent 3 pay stubs. Once the papers are received by the USCIS, you can go on your unpaid time off. *5 if you have a follow-up question on this. Press *5 on your telephone. Okay, this was the first frequently asked question. Next frequently asked question is what to expect from H-4 EAD revocation. Interestingly, I had a call this morning, actually an email from Times of India. They were asking the same question because the regulatory agenda has just been announced. So under the new regulatory agenda, Trump wants to change the definition of employer-employee, specialty occupation, and there was about the wages. They want H-1B wages to be changed. So the bottom line is some of these things he can change a little bit. Some of these things he can change a lot, like employer-employee relationship definition. Some of these things he cannot really change at all. Specialty occupation has been defined by statute. So we'll see how it works. And in any case, by the time they implement this regulation, I would be surprised if less than a year has passed. Regulations are announced every year. It doesn't mean anything. For the H-4 EAD regulations, these regulations have been pending approval. I believe whatever the office is, I don't remember which office is pending right now in, but this has been announced almost 6 months, 8 months ago. Nothing has happened so far. Even if they revoke the H-4 EAD, I think it'll be hard for the government to justify why they are doing it. I think that both regulation and deregulation has to have a justification. You can't just wake up one morning and say, because I don't like Obama, I am going to undo everything that he has done. That's not a good enough reason. In a national economy where the unemployment is less than 4%, I don't see how they can rationalize taking away H-4 EADs. They might get sued on it. First of all, we don't know how those regulations are going to come about. Typically, the regulations have to provide a mechanism for easing out of the H-4 EAD status. They can't just have an abrupt date. Tomorrow you won't have an H-4 EAD. There has to be some sort of a sunset period. Now, remember that first the regulations will be published. They haven't been published yet in the Federal Register. Then they give you either 30 or 60 days to respond. Now, they should give 60 days because these are important regulations. But even if they give you 30 days, make sure that everybody makes a comment. Make your voices heard. There are 2 reasons for that. One reason is you should have your opinion heard. and government has to read each and every comment. They may not respond to every comment. They can respond in a group if the same question is being asked or same issue is being presented, but they have to go through the whole thing. And if I remember correctly, last time when they had, I think, H-4 EAD regulations only, when they published these regulations, I think they had like 50,000 comments or something like that. And it took them almost 6 or 7 months to go over just the comments. So it's not going to happen overnight. Janaki says, I'm on H-4 EAD working in a full-time job. What are my options to continue my job if the H-4 EAD is revoked? There are not a whole lot of options. You can join masters and you can get CPT, but government is now saying that CPT OPT combined can be only 1 year. So there isn't a whole lot of options. Once we know the final regulations, we'll be able to guide you better, but right now this is all we know. So nothing is going to happen overnight. If you go to OPT or CPT together, that can be only 1 year at one level. Master's degree, 1 year. PhD, 1 year. So if you've done 7 months of CPT, you'll get 5 months of OPT. *5, if you have a follow-up question on this, *5. Press *5 on your phone. Okay, all right. Now, this is another very common question from AX 341. Options for career or school while employment-based green card is pending. So they've been working for an H-1B on H-1B for an IT consulting company. Employer will file I-485 in about 2 months. What are the scenarios and what will happen to my green card if I take a job with a different employer? May not be the same or similar job. If it is not same or similar job, you will keep your priority date. The moment your I-140 is approved, the priority date becomes yours. But you will have to start the green card process all over again. Okay. Leave and join a graduate program after I get an EAD. That is the more problematic scenario, because the green card is based upon your intention to accept the job. But if you go back to school, government can raise 2 objections. One, it doesn't look like the job is really available. If it is available, then who is doing it while you're gone to school for 1 year or 2 years? And second, if you're looking for a different degree, for example, an MBA, do you really intend to take up that job? They have not really made an issue of it, but then Trump is bringing all these, their administration is trying to deny and find excuses to deny. So I would be hesitant to say that that's a safe option. Leave the employer and leave USA to go to home country. I may or may not take a job in India which may or may not be same or similar. Well, if you go to India, the only thing you will keep is your priority date, and the priority date will remain yours forever. The only time you lose your priority date under the current regulations is if your I-140 is revoked for fraud or misrepresentation, or from egregious error sort of situation where they shouldn't have approved it. *5 if you have a follow-up question on these issues. *5 on your phone if you have a follow-up question. Okay, let's go on to the next one. This is another frequently asked question. Oh, guys, try to be a little quicker. This is a wireless caller from, let's see, from Colorado. Okay, Colorado, go ahead, please. Area code 719. Area code 719. Hello.
Hello.
Yes, ma'am.
Hi, Rajiv. This is Janaki speaking.
Yes,
on this H-4 EAD revocation doubt. So I just have this question, like, So I heard some positive news on H-4 EAD recently. So will it be a complete positive news, or will there be again discussions on that?
Well, I have not heard any positive news. If you have heard something positive, please share. I would like a little smile today.
No, it's just that they will be. It's just that what you have told just now, that they won't be. Since the unemployment rate is really low, so there are less chances of revoking it. Such kinds
Yeah,
of news.
but Trump administration is not really concerned about what is good for the country. They just want to get rid of all the immigrants. So that's their agenda, and I see signs of it every day. Now, don't depend upon that as being a given. The only reason they would back off is if they know they're going to lose in court. Okay.
Okay.
So yeah,
Okay.
don't depend upon any good news coming from this administration.
Sure. Okay.
All right.
So there won't be any. Even if I join masters and take the get the CPT.
Well, I told you the problem with the CPT. You've got a
Yeah.
maximum of 1 year.
Mm-hmm. Okay. Okay. Yeah.
All right.
Thank you.
You're welcome.
That's it.
You're welcome. Good luck.
Thank you. That's it.
So try to be a little quick, guys, so that I don't have to go back to the question. So options for career or school, we already talked about that. Now we were going to talk about green card job promotions. So let's say I joined as a systems analyst and my green card was filed as a systems analyst, but now I'm getting promoted to team lead or product manager or something like that. What happens to my green card process? Well, technically, your green card process can be reset. However, if the I-140 is approved, you will carry the same priority date even if you have to restart the green card process. So for people who are born in countries that are very backed up like India, it doesn't make any difference because the priority date is the most important thing, and that you will carry forward. You have to start from the beginning if there is a substantial change. There are other theories that can help you protect the job. I would have you talk with your lawyers about those. But overall, I think the safest thing is if your priority date is backed up, go ahead and start a new green card. It's so much easier than try to deal with dicey arguments. *5, if you have a follow-up question on this, press *5 on your phone. Okay, we have a follow-up question. This one is from California. Yes, California, go ahead, please.
Hello, sir. Good afternoon.
Good afternoon.
So if we change the question is within my organization, more or less the job roles are same, but it's a different cost center altogether. They have different cost centers within the organization. So does it require any specific, if the role or the role description being the same, but changing the cost center, will it have an impact to start the process again?
Are the cost centers at different locations geographically or same location?
Same location. It's all based within North America.
It is no, not North America. Within normal commuting distance, 40, 50 miles, 60 miles, somewhere there.
No, it will be a different location.
Well, then it depends upon the way the green card was drafted. When we draft a labor certification, and most lawyers do that, and we know that the job could be potentially transferable, we then file through the corporate headquarters. That way you can keep moving locations and your green card can still go on. So again, there are options here that you should discuss with your lawyers, but it certainly doesn't mean that you can't take this job. It simply means that you've got to prepare for it. Normally, changing jobs within the same company with a similar role, even though for a different department, is not a problem. Okay?
Okay.
Good luck, sir.
Okay, sounds good. Thank you so much.
You're welcome. Okay, so then next frequently asked question. Do we have any more? No, it doesn't look like it. Okay, so let's go back to the normal questions. Corinne Willis says that I have a lot of questions. My sponsor passed away. So I am assuming you mean they're dead. I don't know what kind of a case you have and what kind of sponsorship you have. If you are on the phone, press *5. Okay, there's not much I can tell you. There are some exceptions for family-based sponsorships. There could be an exception if your employer was a corporation and not an individual. But I don't know exactly what your situation is. Sorry. Oh, by the way, before I waste your time, guys, I will not be answering any questions related to DV lottery. That's not an area we practice in. Normally, you don't need lawyers for DV lotteries. So we haven't done a DV lottery in decades. I will not be answering any questions. I don't want to misguide you. Zoomer123 says, I have a couple of friends on H1. They would like to convert to F1. Can they convert within USA? H1B candidate wants to join for masters. What are the options? He wants to take day 1 CPT. If he needs to change status from H1 to F1, what are the steps we need to convert from H1 to F1? Well, there are a couple of problems these days. One of the biggest problems is F1 conversion or change of status is taking so long that by the time it is time for you to go to school, there's a gap between your earlier status and your F1, and government refuses to give you status within USA. So it's a lot more complicated because of delays. Converting from H1 to F1 is easy. You take the I-20 from the school and using form I-539, apply for F1 and a change of status to F1. But the times are too long. If you can continue working on H1 while this is pending, great. But if you cannot, it becomes quite difficult. I would recommend very highly, if that's what you're seriously considering, take a one-on-one consultation, explore all the issues, talk with your lawyers, see what they suggest. This is not a very easy question to answer, simply because, and again, the complicated factor is the delays. H1 to F1 takes too long. Is it not better to go get an F1 visa stamping? What are your chances of getting an F1 visa stamping? What is your background history? There are all these questions we need to consider. *5, if you have a follow-up question on this, I have a second part, I'll answer that too. *5 on your phone if you have a follow-up question. Okay. Second part is H1B is denied and I-94 is expired. Denied H1B case reopened and filed another H1B with a different employer. Can he join master's degree? So basically what you're saying is there is a case pending. H1B denied, I-94 expired, denied case reopened. So a reopened case is just like the case was never denied, right? So can they join masters while the case is pending? And the answer is, well, I don't know. Why? Because while you are in a pending status, you are in something called authorized period of stay. You're not really in full status. And from that on to another status is usually not permitted. So if the H1B is reopened and reinstated and you got your H1B approval, then you are fine. You can definitely, subject of course to the delays, shoot for applying for H1 to F1 change of status. *5 if you have a follow-up question. *5 on your phone. I don't understand this acronym. You said in both scenarios, is IELT mandatory? I don't know what that is. Sorry. Next question is from Khoj.396. Currently working with employer A on H-4 EAD. They filed H-1B. Petition selected in the lottery. Well, good. If my petition is approved, can I change to employer B before October 1st? I don't know the answer to that question as of today. We used to be able to do it, and we did it, changing employers before October 1st for quota cases. But I would like to have this issue checked just to make sure that you're not stepping into something that you cannot step out of. Okay. So can you do it? I believe so. Like I said, we've done it before. Should you do it? That's another question. Somebody should take a look at the law and the policy the government has in this regard. I don't know the whole shebang off the top of my head. *5 if you have a follow-up question. *5. Okay. This is from Oregon. So, Oregon, go ahead, please.
Hi, Rajiv sir. This is me, Coach 396. On the question that you just answered on H-4 EAD, so a few specific questions, and I know that you said that we have to check, but assuming that, my H-1B gets approved and I find another job between now and October 1st, in previous circumstances, how was H-1B transferred? Was it a new H-1B application which was non-exempt that the new employer was to file for me? And just because my name already came in the lottery, I don't have to go through the lottery process? Or it's an H-1B transfer case. I just want to know a little bit of more color on that would be really helpful.
The problem is nobody really knows how to deal with situations of transfer over before October 1st. And I would like this double checked before you take any action. This is an important benefit. You can't just take a leap based upon a guess I'm going to make. It used to be, government always said, you can certainly do it as long as your H-1B is not revoked by the old employer before October 1st. On October 1st, you're automatically on H-1. You can change employers and do a change of employers just like anybody else. But if your case is revoked by the old employer before October 1st, government used to say, I'm not sure they say the same thing now, because with this government, I have to call them about every small thing just to make sure I get it right. So it didn't used to be a problem. I don't know if it would be a problem now if you change over before October 1st, but it definitely used to be a problem if there was a revocation before October 1st, and I think that will continue to be so. Does that help?
It does, and I'll do some more research and have more consultations.
Approach it a little carefully. There are some issues that are tertiary or quaternary, which are not anywhere to be found easily. So in immigration law, you have the primary issues. We know what the regulations say. We know what the statute says. We know what the government's published policy says. Then there are secondary issues, which are a matter of practice. And then there are tertiary and quaternary issues, which are neither written down nor is there a policy. We suspect things are a certain way. Government has been inconsistent. This is one of those areas. Okay?
Okay, thank you.
You're welcome. Next question is for cross-chargeability from PO Box 8284. Wife is from South Africa. Can she apply for a diversity lottery? And the answer is yes. Can I apply for her green card through her as well? Yes. You can apply for multiple categories. Whichever one comes first, you can take that. Shouldn't be a problem. *5 on your phone if you have a follow-up question on this. *5. Okay. TJS says, I'm on J1, wife is on J2, waiver is approved. Got my I-140 approved under EB1A category, but the dates are retrogressed. J1 is expiring in 4 months. I couldn't get any H1 sponsors. can I revoke my J waiver so that I can extend my J1? I don't think you need to revoke it. I think all you need to do is just get a J1 extension. If they can give it to you and the new J1 has a 2-year home residency, it automatically gets reinstated. There's no other formality you have to complete. *5 if you have follow-up question. *5. Okay. So next question. Sorry, Jambird, I don't do DB lotteries, so I'll have to skip this question. Here's another interesting question from B. Sundar. Is there something called hobby income on H-1B? So if he's a cricket umpire and he gets paid, but while he's on H-1B, is that a violation of his status? And the answer is, it depends upon the category that you are going for. Under, for example, professors, college professors, if they get honoraria or fees for lectures delivered, or they write a book and get some royalties out of it, I believe the government will let it slide. But can you do this as an umpire? I do not know the answer to that question. It will have to be researched. My guess would be probably not. My guess would be probably not allowed to take this income. *5 if you have a follow-up question on this. *5 on your phone. Okay. Next question is DB lottery. I'll skip that. Next question is a investor visa situation. So their I-526 was declined and was sent back to USCIS for revocation. Question is, what do they do? The answer is, as you know, you said that you do understand that they might revoke or reaffirm. How long would it take? I really cannot predict that. I would say the normal default for any government action is 6 months, but it can be longer or it can be shorter. So I'm not going to be very useful in answering that question. Second part of the question was from Ganjan Mante, that my son wants to go to USA Northeastern for master's program in fall, but he's also a beneficiary under EB-5. Would he be able to successfully receive an F1 visa? I can only say that try. Government is unpredictable. It's ultimately the call of the US Congress. Sorry. I lost the train of my thought for a second. The interviewing visa officer, the VO. So it depends upon the visa officer. If they want to give an F1 visa, even if you've been named as a beneficiary in a case, they can. In fact, when I came to this country on an F1 visa, I had a green card pending. *5 if you have a follow-up question. Okay, I forgot to answer. What is a successful approach? All you can do is try. There's no guarantee that he will get it, but ultimately, if they are able to convince the consular officer, the visa officer of their good intentions, chances are pretty good. Why not? Okay, next question is from Ladol Patel. EB to 2014 I-140 approved and priority date from 2009 was retained. In 2019 filed I-140 with 485 without attaching medical report. I-140 is approved, received EAD, I-485 is still pending. So, changing jobs. Filing AC21, is it mandatory? And the answer is, well, you see mixed reviews because it's different in different cases. I'm not going to discuss the whole law, but I can look at your case and I can tell you what I think you need to do. If you join a new company after 180 days, you're not required to automatically file a supplement J, but you have to file as and when the government asks for it. So what I tell clients is that if you know you're going to be at this job for a long time, file supplement J. But if you feel that you're not going to be here for more than 6-8 months, you might want to consider skipping Supplement J unless government asks for it. Okay? Who needs to file AC21? My employer or me? Well, AC21 is filed by you, but Supplement J is signed by the new employer. So it's a joint effort. But you do the majority of the work. The employer just has to sign the Supplement J. Who will receive an RFE? 485 RFEs should always come to you because it's your application. Can I submit independently without my previous employer's help? I do not know what you mean by that. I guess what you're saying is that I've gotten I-140 approval through an old employer. So, and you've moved over. Okay, I got that. Yeah, one second, sir. Let me just try to understand this. One more second. I'll open. I see that you have your hand up. So, if you join the new company, who will receive for the RFE, you will receive. If you do an AC21 portability, you will receive the RFE, not your lawyer, or not your employer, because that becomes your case at that point of time. And you can respond, and you should respond to it. If the old employer cancels your green card after 180 days, it does not affect you at all, not even a little bit. Does the new employer need to support green card process? Just signing the Supplement J is usually sufficient. So run it by your employer. I see you have your hand up, and this is from New Jersey. So go ahead, please. New Jersey, go ahead.
Hey, Rajiv. Thanks for answering the question. I think you were asking regarding can I submit independently without my previous employer?
Oh, absolutely. Absolutely. You don't need them. They are out of the picture.
Okay. So once we switch to the new employer, is there a chance they can ask for any documentation from my previous employer?
After 180 days, they can, but if I were your lawyer, I would say, I'm not giving you any documentation. It's over 180 days. Old case is done and gone.
Okay.
They can ask.
For my new employer.
They can ask.
Okay.
The only time it becomes a problem, Mr. Patel, is if they are alleging some kind of fraud or misrepresentation. Then it becomes very complicated. But if there's no fraud or misrepresentation, they just want, for example, tax return of the old employer, I would say, I don't have any access to it. I'm done and gone from there.
Okay. So as long as we file Supplement J, which is signed by my new employer, that should be it. After that, probably we don't have to touch base with old employer, get any documentation in case government comes back.
But my recommendation, not as a lawyer, but just as a human being, would be don't throw something at their face when you leave. Maintain good relationships so that if you have to reach back to them, you can. You shouldn't have to.
Yeah.
Okay. Yeah, just don't throw your laptop at them, so when you leave. Okay?
Okay, thank you. And then for Supplement J, I think it should be okay once we join the new employer and then file for Supplement J, right?
Actually, Supplement
Or do we need to file before?
Supplement J is an interesting situation. The law, as I recall it, there's so many variations in this theme, sometimes I forget. But the law, as I recall it, it says that in a situation like yours, you do not have to file Supplement J at all. If you want to, you can file it a year before you join also. We will actually adjudicate the Supplement J and you can then join if we have approved it. If you decide not to file at all, you will only have to file if we send you an RFE. Okay. So once again, filing a J1 Supplement J is not required. If you choose to file it, if you choose to file the Supplement J, that's fine. If you change employers, you can file another one later. But if you choose not to file a Supplement J, you only have to file it when we ask for it. Okay?
Okay, so definitely I'm getting RFE for the medical report. So in case I already changed the job, I can file along with that?
Yes, sir. if they ask for it. But if they don't ask for a supplement J, it's your call. I usually like to file it. It offers you some additional protection, in my opinion.
Okay. And when we file AC21, just last question, does it impact my H-1B? Because recently when I got the 3-year extension and I'm planning to continue use that, so when we file AC21, the H-1B case is gone, right?
No, not at all.
Or status?
Not at all. You can do a H-1B transfer also at the same time.
Oh, even though we file AC21?
Mm-hmm. That's what I do, because I want to keep every possible protection open for our clients.
Oh, okay.
All right.
So H-1B can also be transferred during the green card or AC21.
Absolutely.
Okay.
Absolutely.
Okay.
Okay.
That's useful information. Thank you, Rajiv.
You're good. Good luck, sir. Good luck. Okay. So now Indian Desi says Namaskar ji. Currently on H-1B 10 plus years, all with a single employer. Priority date is September 2009. I-485 was filed in March 12. I guess that's 2012. AOS interview completed successfully in October 12. Priority dates had regressed, so immigration officers said they couldn't stamp my passport. So the question is, now see, when your I-140 is approved, and I'm assuming that's approved, it doesn't say very clearly, but I'm assuming it's approved. So question is, due to possible layoffs, I plan to join a new employer on H-1B transfer. What form steps does my new employer have to file? We just discussed this. If you just listen to the previous discussion with Mr. Patel, exactly what we talked about. You don't have to file anything unless you choose to. If you're going to stay somewhere for a while, couple of years, I would file a supplement J. Other than that, the new employer doesn't have to do anything. And the jobs have to be same or similar. But if they're offering you a totally different job, they'll have to start the green card all over again. Second question, I have a better offer from another employer. They want me to join directly on EAD. Is it safe? I would like to maintain the H-1B, but you can do, if the job is very lucrative and you like it, you can join on EAD, but make the condition that they will process your H-1B. They will process your H-1B, you will get it without I-94. Somewhere along the line, you can go to Canada or Mexico, get your H-1B visa stamp. When you come back, you are back on H-1B instead of being on EAD. So in other words, you can join on EAD, get the H-1B transferred, somewhere along the line, go back on H-1. Then, third question, I got married in 2014. Spouse could not be added. That's correct. Is there any other way to add her sooner? No. Will USCIS call me again for a green card interview when the dates become current? The answer is we don't know. Normally, no. But they can. Normally, after the interview is over, they're not going to call you for second interview. But I have cases where second interviews are asked for, especially from the fraud detection unit. *5 if you have a follow-up question. *5. Okay. So the last question for the day from Harini is, considering taking 1 year break because of pregnancy, and I'm going to go to H-4, how soon can I quit my job? As soon as you file the H-4, you can quit your job. You don't have to keep working. As soon as you file the H-4, and by filing I mean when the government receives it. My employer will not revoke. Okay, next question. Do I have to keep working? No. Once you file, once the government receives your H-4 papers, you can quit working. I would be more comfortable if you waited till you got your receipt, just to make sure that it's all taken care of. Any other legal issues if they don't revoke my I-140? No other legal issue. And by the way, under the new rules, if your I-140 has been approved for 180 days, and even if they revoke, your H-1B extensions beyond 6 years are secure with any employer, ongoing basis. So really you are 100% safe after 140 has been approved for 180 days. When you return back to the H-1B with the same employer, is the I-140 still valid? And the answer is that depends. See, if the job is still available and it was a real job, government can question how come they let you go for 1 year, who was doing your job. And if you have satisfactory answers, for example, the employer is a large employer, they have 1,000 plus people, anybody can share jobs or they can hire temporarily somebody else. So if the job continues even in your absence and somebody else is doing it or a bunch of people are sharing it, you have no problem. The I-140 will be valid. That's the only issue. Star 5 if you have a follow-up question. Star 5. Okay. Let's see. We still have some time, about 15 minutes. Anybody has any question, press star 5, please. Anybody has any question, press star 5. Oh, wow. This is the first. Nobody has a question? Excellent. Very good, guys. I'll talk with you again in 2 weeks. We are trying to stick to the schedule. We had to skip a time or two in between because of certain pressing work. But I will see you again in 2 weeks, and I really enjoy talking with you. Thank you for the opportunity. Take care, guys. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.